In today's lecture, we're going to be looking at Chapter 13 of the text concerning trials and juries. The history of trial by jury goes back to Athens in the between 5 and 600 BCE, which is before current age. We see the system develop further through the Roman Empire. We see it first in Western Europe, in France, in the 800s. That's CE, current era. We see it more codified for the sort of development of about how it's gone to present in the Magna Carta, 1215, and then we see it in the United States Constitution, in Article 3, and the Amendments 6 and 7. And what we're talking about here is basically petty juries as opposed to the grand juries that we see deciding the issuance of an indictment before the trial process starts. We're talking about trial juries, or they're all also called petty juries. For any offense where an individual is facing any sort of serious charge in civil matters more than $20, any sort of serious felony or high misdemeanor, the right to a jury is basically absolute. It's not implemented for youthful offenders. We wouldn't impanel a panel of children to hear them, so there'd be no jury of their peers. However, in any instance where a jury trial would be applicable, the defendant can request a bench trial, where the case is heard instead of by a jury by a judge. We've touched on that in the past. So jury size, the most common size is 12, although it can be 6 for smaller offenses, more minor offenses. There is an issue with having smaller juries where you have the potential for bias in a situation become more problematic when you only have 6 jurors as opposed to 12. Also, you're less likely to have more open debate, and you can't have a situation where one member of the jury sort of dominates the discussion about what's going to be happening. Also, the entire process of the deliberation can be taken over more easily when there's less people. For the most part, cases that are being decided by a jury, criminal cases, have to be a unanimous jury. For civil trials, it doesn't have to be unanimous. In most instances, it can be 9 of 12. Usually when there's 6, it has to be unanimous, but if there are 12, then in some instances there can be where it's basically just I believe most places are going to require a supermajority, so it's 3/4 of the jury. In the case of 12, it'd be 9 out of 12. There are a few states that do allow for non-unanimous jury convictions of criminal trials, but it's more less serious offenses. Any type of a capital situation or a murder trial is going to be required to have a unanimous verdict. So the way that juries are selected, there's a master list for any given jurisdiction, and that's based on voter registration. It's based on DMV registration, either for ID cards or for driver's licenses, property tax records, utility bill, really anything. They try to get as many people in there as possible, because before, when they were just looking at voter registration, if you were registered to vote, you wouldn't be on a jury. If you were from a population that had issues with systematic under registering to vote, typically, we're talking about poor minority communities, then those individuals would be underrepresented in the jury pool. So they tried to expand the pool from which they collect those lists to better represent all aspects of society. In some places, they have better responses to jury summons. Typically, we see between 9 and 66% of non-response. So it really just depends on where you're at. It is required, and uh, you can be potentially charged with a misdemeanor in some jurisdictions for not showing up for jury service. Although it doesn't happen that frequently. If it's a situation where it's a particularly high-profile trial and someone doesn't show up for jury summons, then they might be more likely to face um, consequences from that. But it is something that should be done. If you get summoned for jury, you should definitely show up. Eligibility to be accepted into the veneer, which is the group of people in which the jury will be selected. Um, you have to be over 18. Typically, have to be able to speak and read English, free from mental health issues that would prevent you from participating in the process. Felons are not permitted to be on juries in most jurisdictions. Many government officials are excused from service as well. Medical personnel, because they have to, they're required to be serving a more important task, especially in the current situation. Clergy, educators, also students as well. If you get a jury summons in the middle of a semester, you can typically forward your school schedule to the relevant person in the county or city wherever you've been summoned, and they'll excuse the service or delay it until you're not in session. Lawyers aren't particularly good members of the jury. That typically they get excused because one side or the other doesn't want them on the case. They don't want the jury pool to be dominated by one potential attorney. It's the same way a lot of criminal justice personnel. um, there's typically a time frame. They don't want people serving. If you get some sort of glitch and you get selected to serve every year, that'd be a little burdensome on individuals. So they try to break up. That it's not going to be every year, maybe every 3 or 5 years, depending on the area where you're in. And then individuals over a certain age can sort of ask to be excused, again, just to try to remove any sort of imposition that we put upon them and their daily lives. So once that veneer has been selected, they will then go through a process which is called voir dire, which basically means to speak the truth. And they're going to be asked a lot of questions. A lot of questions relative to the case, some questions that may not seem relevant to the case. A lot of times, this will be done, at least preliminary voir dire will take place online. So if they'll ask you, have you had this type of insurance? Have you been involved in a car wreck in the last year or so, something like that? And that can exclude a lot of people from having to come down to the courthouse and can really better trim down the veneer to a more manageable group to pull the jury from. It's you're basically duty bound to tell the truth. There are some people that lie to try to either get on the jury or get off the jury. This is something that just has to be dealt with on a sort of case by case basis. There are two types of strikes that attorneys can use to remove a potential veneer member from the jury pool. Strikes for cause are things that come up during the questioning process or in the basic background information that's brought to the attorney's attention, and they can be any number of strikes for cause. Depending on what jurisdiction you're in, the attorney is going to have a certain amount of peremptory challenges, which is when they can remove a member of the jury pool from consideration for no reason. If, however, the judge determines that they are removing people by some sort of systematic basis of race, sex, ethnicity, anything like that, then the lawyers can be in trouble for bringing bias into the jury selection process. Although the requirements and the things that have been allowed to be taken in consideration for removal of a jury for a peremptory challenge are pretty widespread, ununiform, and in a lot of instances can be used to skirt the the requirements for not engaging in sort of biased jury selection. Additionally, by asking questions of the jury and getting information for themselves, the defense attorney and the prosecution can also use those questions to sort of set the stage for the arguments that they're going to make at trial, and sort of bringing the jury up to speed about what the issues that are at play here, and sort of have a feedback loop of trying to get people on their side. Additionally, in the last 20 to 30 years, there's been the development of jury consultants, professionals that are well versed at reading the juries, doing the legal background information, and collecting that, and then giving the attorneys recommendations about who to strike preemptively, who to strike for cause, what are some of the causes that can be brought up that they could be removed from, and also what type of jurors might be beneficial or sympathetic to the case or the issues that are going to be brought up. There are some presumptions at the trial process: the presumption of sanity, that the person is sane and competent enough to stand trial. Also, the presumption of innocence, guilty until proven, or innocent until proven guilty. Excuse me, innocent until proven guilty. That's a very important aspect of the American court system. You also have the burden of production, which is if you want to argue something based on facts or evidence, you have to produce facts and evidence to support that argument. Then also the burden of persuasion, which falls upon the prosecution in criminal trials to prove in the jury's mind beyond a reasonable doubt that the defendant committed the offense. Some types of evidence that are brought up in the trial process. Direct evidence is things that are collected that are explicitly indicative of the crime taking place as the prosecution has directed it, or so for instance, a pretty clear example of this would be if someone was on video actually murdering someone, that would be direct evidence. If you had the difference between direct evidence and circumstantial evidence is that if you had video of the person being at the scene where someone was murdered, but not actually on video murdering them, that would be circumstantial evidence. It's not a direct a direct indication that the crime has been committed by that person. You also have testimonial evidence, which is where witnesses or people with pertinent information give testimony about what they saw or what they know. Real evidence is the sort of physical things, video or audio recordings of something happening. Scientific evidence is brought through forensics, running DNA tests, things like that. Demonstrative evidence is not necessarily could even be not necessarily evidence of the crime that took place, but it could be an overview, sort of a satellite map of the area where it took place. Things that show the conditions or the environment where something took place. That's a big one too. Just the satellite information that used to be very expensive evidence to get because there were it would be hard to get that information. But now you can just go to Google Maps and get a satellite view of any area, just about any area in the United States. Some of the rules of evidence that dictate how these the stuff is brought up at trial. There is the idea of the best evidence rule, which basically means that copies of things aren't going to be allowed. If you have the original version of a receipt or an invoice or something like that, that needs to be brought in as opposed to a copy, because copies can be easily forged. You want to make sure that the evidence is held in a proper chain of custody. When evidence is collected by the police, it's put in an evidence bag, and there is a There's usually a form either with that or on the bag itself where anyone that handles the evidence has to write that down to see when that happened. Um, you have to make sure that people that are going to testify, witnesses, are competent to do so, and they're not sort of free from any sort of mental health condition that might negatively affect their ability to participate in the trial process. You also have to make sure that the evidence that they're going to testify to is something that they themselves witnessed. It can't be someone told me that this happened. Um, be a violation of the hearsay rule. The only exception to that really is the dying declaration, or if someone is dying and says something to someone, that is usually allowed at trial. Um, it's sort of a long-standing legal precedent that people that are about to die have less of a reason to lie. You also have to make sure that the evidence is relevant to what's happening, and not unduly prejudicial. Sort of the next thing. Also, it's not repetitive. People aren't testifying to the exact same thing. Um, that's a situation where the judge might rule that the first person can testify to it, but the next three, if they're going to testify to the same thing, there's no need for that. There's also the issue of privileged information, whether or not the information was exposed in a someone, the difference between someone eavesdropping on a privileged conversation versus someone being in the room for it, can affect the ability for it to be brought at trial. Um, and then the opinions of what we'll call non-experts or lay persons, typically have to be uh, restricted to things that are easily observable. So you can testify that someone was acting drunk, but you can't necessarily testify to the effects of alcohol ingestion on behavior if you're not a specialist in that field. To that point, expert witnesses has to be relevant to the trial, what they're testifying to, based on facts and accepted data, reliable methods in the scientific community, and there's a lot of debate about what some of those things are. What are the best practices? There are some things like some of the ballistics tests that we've been doing, dental records, and things like that, that maybe don't have the best basis in scientific fact. Um, so from time to time, there needs to be a review of some of these processes, to make sure that they are all scientifically valid, and things that should be brought in a trial process. We also have the issue of the CSI effect, which is an effect on juries, that they expect more evidence. If you've ever seen the show, terrible show, terrible show. All of the spinoffs are terrible, but a lot of people watch them, so they expect when they go to a jury that the defense attorney or the prosecution is going to have the results from the butterfly database to see what kind of pollen was deposited upon the body and all this other nonsense, that typically doesn't get collected in a trial process and the collection of evidence. It's not feasible. Even fingerprints are only going to show up in 25% of cases where you're going to be able to get an actual, solid match on fingerprints. So juries expect these things, and then when they don't see them, they've had a tendency to acquit defendants who are basically dead to rights with the evidence that the prosecution presented in the cases they presented, but because they didn't have those bells and whistles CSI evidentiary collection, the person gets off. So it's sort of a direct effect of the media consumption impacting the way that juries do their jobs or the tasks that they've been assigned. If so, when the defense and the prosecution put forth what their case is going to be, that's where you can make objections to the evidence being admitted. This can happen before the trial as well. If there's an issue with a police search, or the relevancy of the information, or the pertinence, or the actual level of expertise with a expert witness. For instance, if you hire someone to discuss that a case was based on satanic ritual, and the person received their master's degree or their PhD degree through a mail order university, never took any classes, hopefully the judge in that case would view that expert witness as less legitimate and potentially not allow them to testify at trial. It really just depends on what the circumstances are, how the evidence fits into the trial process, how it was collected, as to whether or not it can be excluded from trial. As we talked about before, the developments in forensic science and their application in criminal trials was probably too fast. So we're in a situation now where we have scientific method that is discrediting various types of evidence that we've seen as forensic science in the past, but really wasn't. Bite mark analysis and some of the ballistic. The main thing with ballistics is they used to believe that ammunition could basically be traced to batches or even to the same box of ammunition. That's really just not the case. There's also a lot of issues with bite mark analysis, even some of the blood splatter analysis. There are some glaring, flagrant issues with the things that we've allowed to be admitted as science in criminal cases when it really wasn't. The urge to want to implement these techniques at trial basically drove people to accept them as scientific process and scientific method before they were really thoroughly and vigorously tested. So the steps in the trial process, you have the opening statements. The prosecution goes first, and then the defense attorney. You then have the prosecution case. Basically, they present their entire case. Then, more often than not, the defense will make a motion for a judgment of acquittal, saying that the prosecution hasn't proved beyond a reasonable doubt that the case, the facts of the case as they stated them. Usually, the judge is going to overrule that. Although it does happen that some cases will have a directed motion accepted, and the judge will issue an acquittal at that point. If that doesn't happen, the defense will then present their case. Potentially, the defendant will act as a witness for themselves, although that's usually a latch. So, contrary to what media and fictitious reports of trials would have you believe, the defendant typically doesn't testify. If the defendant does testify, it's kind of an oh shit Hail Mary moment that the case is going sideways and we need to basically pull this last ditch effort out. So it's uncommon for a defendant to testify in their own trial. Although when that does happen, the media kind of latches on that and says, "Oh, why didn't they testify?" It's because they don't have to, because they shouldn't, because they're more likely to say something stupid when they're being cross-examined by the prosecutor than they are to say something that's going to benefit their case when they're being interviewed or when they're giving testimony based on the questions of the defense attorney. Following the presentation of the defense's case, they're going to renew that motion for a directed verdict of an acquittal. Again, typically doesn't happen. Following that, the prosecution can then offer rebuttal witnesses and testimony. Following the opportunity for a rebuttal, then we have the closing arguments. The judge then issues jury instructions telling the jury what the charges are again, what elements of the crime have to be met and proved beyond a reasonable doubt for those cases, for those charges to be, the individual to be convicted on those charges. The jury then deliberates and then comes to a conclusion. Usually that's going to be guilty or an acquittal. Acquittal does not mean innocent. Juries do not find people innocent. They find they are acquitted of the charges based on the procedure of the court system. So acquittal does not mean innocent. They can, however, find people guilty, which would then result in the jury or the judge issuing a sentence. If it's a very serious high-level felony, sometimes you'll have a sentencing phase where testimony and evidence can be brought up that might not necessarily have been relevant at trial, but it could be relevant to the sentence. And then you have a whole variety of post verdict motions. A motion to remain on bail or bond pending an appeal is a common one, oftentimes denied. The appeal process itself is built into these motions. So just depending on what the defendant wants to have happen in a case, or what the convicted person wants to have happen post verdict. Some of the other issues at trial that come up: jury nullification, where even with a presentation of a lot of evidence, the jury finds the defendant innocent, or sorry, acquits them. Again, they don't find them innocent. The jury sets aside the information that was it's happened recently, where potentially juries of the community don't want a person to be convicted of an offense, and so they acquit them. In the past, it was more problematic. In Jim Crow South, even before that, where crimes against particular groups of people. In the South, we're talking about crimes committed against African Americans. The individuals wouldn't be convicted. So it doesn't matter what evidence was presented at the state level trials; they wouldn't be convicted. And then it became the responsibility of the federal government in some of those cases to retry the individuals at the federal level to try to get a conviction to avoid the sort of jury nullification. But you never really know what's going to happen with a jury. They they may have told the truth. They may have lied during voir dire. They may have, they might have a Klan costume in their closet that they didn't tell anybody about. They might be on deep net message boards where they're talking about bigoted issues. They're talking about overthrowing the government. You never really know what actually is going through the minds of the jury. So there can be a lot of unpredictability with the outcomes of a jury trial. And again, that goes into why the defendants seek the pleas, but it also goes into why the prosecutors accept the pleas. The issuing of gag orders is another thing, depending on what level of media attention is happening on the trial. And that goes directly into change of venue. If there has been a lot of media coverage, oftentimes the defense attorney, sometimes even the prosecution, will request a change of venue to avoid undue bias that's been created recently by coverage of the case. If that is seen as going to be a problem, then you can have the jury being sequestered before the trial process starts to try to avoid that from happening. Reducing the number of media coverage in a courtroom. But a lot of this has become more problematic because of these stupid computers that we all keep in our pockets. Before, the judge could say, don't read the newspapers, don't watch they could control the access that the juries have to local television. But with the computers in our pockets, it makes it very, very difficult to block all that out. And you can have media distortion. You can have undue influence on the case, or they can talk about things, or they can look up things that maybe they shouldn't be looking up, or someone could be evidence could be excluded from being presented at trials. For instance, testimony of someone, but that person could then go on Facebook, post a 6-page write-up of why they should be allowed to testify at trial, and the jury might be able to read that. So a lot of information can get brought in that wouldn't necessarily be allowed in if you go through the full process. So it's another quirky development of our modern society and the impact that it's had on the trial process. So that's sort of like a brief overview of the trial process. We should be sort of filling in the puzzle pieces at this point of what the actual operations of the court system looks like, people involved, everything like that. We will move on with the next section in the next PowerPoint.